The EU regulation on the protection of personal data, commonly known as the General Data Protection Regulation, GDPR, is a comprehensive legal framework aimed at safeguarding the privacy and data rights of individuals within the European Union, EU, and the European Economic Area, EEA. It sets out various obligations for organizations that collect, process, and store personal data, as well as providing rights to individuals regarding their personal data. Here are some key legal stipulations within the GDPR. 1. Lawfulness, fairness, and transparency. Article 5(1)(a) of the GDPR requires that personal data shall be processed lawfully, fairly, and in a transparent manner. This means that organizations must have a legal basis for processing personal data, such as consent, contractual necessity, legal obligation, vital interests, public task, or legitimate interests. Additionally, organizations must be transparent about how they collect and use personal data. 2. Purpose limitation. According to Article 5(1)(b) of the GDPR, personal data shall be collected for specified, explicit, and legitimate purposes and not further processed in a manner that is incompatible with those purposes. Organizations must clearly define the purposes for which they collect personal data and ensure that any subsequent processing is compatible with those purposes. 3. Data minimization. Article 5(1)(c) of the GDPR requires that personal data shall be adequate, relevant, and limited to what is necessary in relation to the purposes for which it is processed. Organizations should only collect and retain personal data that is necessary for achieving the specified purposes and should not retain it for longer than necessary. 4. Accuracy. Article 5(1)(d) of the GDPR stipulates that personal data shall be accurate and, where necessary, kept up to date. Organizations must take reasonable steps to ensure the accuracy of the personal data they hold and, where necessary, update it to ensure it remains accurate. 5. Storage limitation. According to Article 5(1)(e) of the GDPR, personal data shall be kept in a form which permits identification of data subjects for no longer than is necessary for the purposes for which the personal data is processed. Organizations must establish appropriate retention periods for different categories of personal data and delete or anonymize data when it is no longer needed for the specified purposes. 6. Integrity and confidentiality. Article 5(1)(f) of the GDPR requires that personal data shall be processed in a manner that ensures appropriate security, including protection against unauthorized or unlawful processing and against accidental loss, destruction, or damage, using appropriate technical or organizational measures. Organizations must implement appropriate security measures to protect personal data from unauthorized access, disclosure, alteration, or destruction. These are just some of the key legal stipulations within the GDPR that organizations must adhere to when processing personal data. The regulation also grants individuals various rights, such as the right to access their personal data, the right to rectification, the right to erasure, right to be forgotten, the right to data portability, and the right to object to the processing of their personal data. Compliance with the GDPR is essential for organizations operating within the EU or processing the personal data of EU residents. Failure to comply with the GDPR can result in significant fines and reputational damage.